Mr Thompson.
I'm obliged, my Lord. I wanted just to have some concluding remarks on the issue of interest. As I mentioned before lunch, the Commissioners had accepted in their written case the principle that interest may be due where there has been a wrongful withholding of a VAT credit. And in my submission, of course, the existence of that entitlement to interest where there has been a wrongful withholding supports, in my submission, the implication of the power for which I contend, because it is balanced by that entitlement to interest. What I wanted to give the Court at this stage, just so the Court has it, is recognising that there is the community law underpinning of the right to interest. There are a number of statutory provisions that deal with this, not one of which I regret to say is in the bundle, but I can give the Court the references, and they are, as the Court might imagine, quite detailed, so I won't attempt to go through them, but I'll give the Court the references. So first of all, within the 1994 Act, there is section 78, subsection 1D, section 79, subsection 1A, and these are both concerned with, among other things, a credit not being paid. But for completeness, section 85, capital A, deals with the powers that the tribunal has to award interest where credits have not been paid. And in particular, it's section 85, capital A, subsection 2B. That was what I wanted to say in relation to interest. The President raised with me the case of Strangewood that's referred to by Mr Justice Lightman and in turn referred to by the Advocate General in Mullen-Haida. That reference, just so the Court has it, is at page 2467 and it's paragraph 23 of the opinion of the Advocate General where that case is referred to. And in circumstances where the case itself is not before the Court, I wouldn't want to advance substantive submissions about it, but if it's of assistance, I can give the Court references to certain passages within the judgment of Mr Justice Oughton, as he then was, which may be of assistance. And they are at page 502 of the report, sets out the detail of the case. And then there are two passages that may be of assistance in this connection, which support, if it essentially supports the approach that Mr Justice Lightman took. And they are at page 505J and the final paragraph at page 506. Now, having looked at those matters that were left over from just before lunch, there are just a small handful of final remarks I would wish to advance in support of the Commissioner's position. The first of those is to remind the Court that at paragraph 75 of the case for the Commissioners, page 111 of the joint bundle, the Commissioners have made reference to a series of cases that show that really from the first enactment of value-added tax in this country, the courts have from time to time considered it appropriate and necessary to imply into the statutory provisions certain powers. And the various cases are given to the court from paragraph 75 onwards in my case. So the essential proposition that it may be appropriate to imply powers into the Value-Added Tax Act is one that has been reflected in the decided authorities thus far. The next point to make, my Lords, is that one does have in my submission to step back and ask what is the essential purpose of the Value-Added Tax Act in common with every other taxing statute, but the answer is provided in my submission at paragraph 84 of my case, page 114. It's to ensure that the taxable person accounts for the correct amount of tax. And if support for that proposition is needed, it can be found at paragraph 64 in the judgment of Lady Justice Arden in Bupa at page 2277 of the joint bundle. Finally, on that point, the case of ISOC that I mentioned briefly before lunch indicates that that's also a central feature of the community approach to this. So ISOC at page 2416, paragraph 52, that the common system of VAT requires the tax to be collected accurately. Related to that is the point I touched upon before lunch, that as well as collecting tax accurately, the invocation of equal treatment or fiscal neutrality by the taxpayer in my submission does not assist. As I showed the court in the judgment of Mr. Justice Lightman at paragraph 18, the availability and proper exercise of the Commissioner's powers are essential to maintain the fiscal neutrality of VAT and prevent refunds being made to parties not entitled to them. In considering whether the power for which the Commissioners contend should be implied, the court was taken by my learned friend already to the powers within section 25 of the Act at page 1335 of the joint bundle. For example, reference was made to the power to withhold by my learned friend. He likewise made reference to Schedule 11, paragraph 4, which contains, for example, powers to require security where a VAT credit is being paid. That's page 1369 of the joint bundle, Schedule 11, paragraph 4. And my submission, my Lords, is if those are the powers conferred by Parliament expressly, where a VAT credit is being given, the position must be a fortiori, where the Commissioners have decided that no credit should be given. They should not be left, in my submission, to give the credit. Indeed, even on the extreme example or extreme approach taken by the taxpayer, pay the credit and then try to recover it. The powers in my submission must instead be implied. I should deal briefly and for completeness with section 73 of the Act. The argument that was advanced this morning by my learned friend was one which proceeded on the basis that the Commissioners should give the credit and pay, and if necessary assess under section 73 subsection 2, and for the reasons I've given already in my submission, that can't be correct. The Commissioners shouldn't be driven to pay out money that they've already decided is not due. The argument that's advanced in the written case for the taxpayer is that, and this is paragraph 96 of the taxpayer's case at pages 85 to 86 of the joint bundle, is that another solution would be to interpret the phrase VAT due or amount due as including a negative amount. So in other words, one would assess where a sum is due to the trader rather than a sum due to the Commissioners. And my submission about that is simply that's not what the language of section 73 says. It's very clear that it's talking about sums due from the trader to the Commissioners. Section 73 subsection 9 says that the amount assessed is deemed to be an amount of VAT due from him and in turn that amount shall be recoverable as a debt due to the Crown. So there can be no prospect of talking about this as a negative amount due to the trader. And that whole analysis about Section 73 that's in the case for the taxpayer is at odds with the approach adopted by Lady Justice Arden, as she then was in Bupa, which made clear that it's an amount due from the taxpayer. The final thing I wanted to touch upon, Lords, is the reference that is made by the taxpayer, in its written case at least, to Regulation 35 of the 1995 regulations. And as I hope I've made clear, my submission is that the dispute that exists between the parties is the taxpayer has submitted returns saying that it considers it is entitled to a VAT credit, and the commissioners do not accept that. And that's the decision that divides the parties. That's what the appeals, as it happens, are in fact about. And what follows from that is there would be no point and no need to engage Regulation 35. Regulation 35 entitles the commissioners to require a taxpayer to correct his returns. It's manifest that the taxpayer here is not going to correct its returns if the commissioners direct it to do so. Matters would not be advanced by the commissioners saying, correct your returns, because the actual dispute between the parties is as to the decision not to give the credit. That's the decision that can be and was appealed. There are three final points about Regulation 35, being these. It's a permissive provision. It confers a discretion on the commissioners to require a correction of returns. That's not indicative of this being the route that the commissioners must use, where the real question is as to whether the VAT credit should be given. The second point is, I commend to the court the analysis of the upper tribunal, Judge Gammy, Queen's Counsel, and Judge Hellier in Benridge Care Homes, paragraphs 38 to 40, at page 2525. And in those passages, the upper tribunal says there's no need to issue a Regulation 35 direction where the decision the commissioners have reached is that no sums are due to be paid to the taxpayer.
When do you use Regulation 35?
Well, Regulation 35 appears to be interrelated with Regulation 34 because it's in its own terms. It says where the taxpayer has not itself corrected the return pursuant to Regulation 34. And Regulation 34 in turn is subject to various limitations as to amount and time periods. But the essential point in my submission, my Lord, is that if there is a power and an obligation to verify, the whole point of that exercise must include the possibility that the commissioners take the view that the VAT credit is not due. That's the power for which the commissioners contend, and it's the one that each of the first and upper tribunals and the First Division of the Inner House accepted arose without any need to become involved in Regulation 35. And finally, in relation to Regulation 35...
Sorry, just to pursue that. So when would you need to use Regulation 35?
So in my submission, my Lord, Regulation 35 concerned with errors in the return, connected, as I indicated a moment ago, to Regulation 34.
Well, I couldn't understand why it's connected to Regulation 34. It is not expressly connected to it. It follows it, but it's not expressly connected.
It's connected as a matter of language in my submission, my Lord. It says...
There's 1369, is that right?
Yes. So it says...
I'm sorry, do you have the page reference for Regulation 35?
Yes, I'm just going to...
1396, sorry. 1396.
Yes, 1396. So where a taxable person has made an error in accounting for VAT or in any return made by him, then unless he corrects that error in accordance with Regulation 34, he shall correct it in such manner and within such time as the Commissioners may require. And that's the connection to Regulation 34. It presupposes that there could have been a correction under Regulation 34.
Well, he has made an error. They did make an error. They made errors in accounting for VAT and in the returns made by them. And they didn't correct it in accordance with Regulation 34.
So
that's why it's limited to Regulation 34.
So the two submissions I'm making, my Lord, in relation to that are, first of all, the reference to unless the correction is done in accordance with Regulation 34 supports the view that what's being talked about here is a case where there could have been correction under Regulation 34 but hasn't been, but the Commissioners decide there should be. But secondly, and in any event, the submission I made a moment ago about the approach taken by the Upper Tribunal in Benridge provides in my submission the answer that if where we get to is the Commissioners, having received the return, take the view that no credit is due, because they have the power to verify, they must impliedly have the power to decide nothing is due.
Right, I mean, I follow all of that, but why do they need the power in Regulation 35?
Well, it can be available in a whole host of circumstances where there are errors within the return, such as arithmetical errors or that kind of thing. But the specific focus of the power for which I contend on behalf of the Commissioners is that if there is the power to verify, as I say the authorities clearly suggest there is,
seeing and just not seeing it.
The end point of that exercise must include the ability to say nothing is due and it's not necessary for the Commissioners to do any more. The final point I was going to make about Regulation 35, and I know this is a point of...
I couldn't understand why the circumstance in which it is used, because the language of instructing somebody to change is somewhat different from the Commissioners actually making a decision.
Yes.
And you're saying a decision is being made here. And so it didn't quite fit in with this concept of a decision being made.
Well, it takes me back, my Lord, to the submission I made, the first point I hope I made this afternoon about Regulation 35, that the real point of controversy between the parties is as to whether the VAT credit should be given. And asking the taxpayer to correct its return is not going to advance matters, because we know they're not going to correct their return.
I'm afraid, Mr. Thompson, that Lord Hodge has a problem with his laptop, which is preventing him from bringing up the legislation that you're referring to. So I'm afraid we'll need to adjourn until that's been sorted out. We've sent for an IT engineer, so it should be dealt with quickly.
So.
Yes, Mr. Thompson.
I'm obliged.
Very sorry, Mr. Thompson, for the interruption.
Not at all, Lord. Really, to conclude on Regulation 35, all I had left to say, and to try and draw together what I had been saying, is it's couched in terms that this is a power, a discretion that the Commissioners may exercise to require the correction of a return. Necessarily, therefore, the remedy to the taxpayer, if the taxpayer were dissatisfied with the exercise of that discretion, would be by way of judicial review. As it happens, the only case that's before this court, the only authority that's before the court, is the judgment of Lord Sales, then sitting as a judge in the Upper Tribunal in capital accommodation, which was a judicial review application. So the fact that one is in the territory of a power reviewable by judicial review rather than by way of appeal, again supports in my submission the view that this is not the basis, this is not the vires for the decision not to give the VAT credit in question.
I mean, from memory, and it was quite a long time ago, I think capital accommodation just proceeded on the basis of an assumption that one challenged a Regulation 35 requirement by judicial review. I mean, we haven't looked at Section 83. I just slightly wonder whether that's right, because if a notice is given requiring a change in a return, I mean, that's a very definite action by the commissioners.
Yes.
Are you saying that doesn't fall within Section 83?
What I say, my lord, is this, that the decision to make a requirement of a correction of a return under Regulation 35 as such is not within the categories of appeal under Section 83. The thing that is appealable, in my submission, is the decision that the commissioners took in this case, which is to refuse to give the VAT credit. That's Section 83, 1B and C that deal with that.
Right, but yeah, I mean, in your answer, you seem to be distinguishing the decision before something is done under Regulation 35. But my point was, if the commissioners decide to use their power under Regulation 35, something definite happens that they, in order to require the taxpayer, they must send some sort of notice to the taxpayer, you are required to make such and such changes. And I was wondering whether Section 83 would apply in relation to that action taken by the commissioners. I appreciate they'll have taken the decision before they make the action,
yes,
but whether the action could be within Section 83.
So my submission, my lord, is that the contention of the taxpayer in this appeal is that in order to act lawfully, the commissioners must issue a requirement under Regulation 35. And my submission is that's not correct. That what they do is they exercise, as an aspect of the verification of the return,
yes,
they reach the decision, the credit is not due. That's the decision, that's what's appealable, that's what...
If I may say so, I follow...
It's just not necessary to invoke Regulation 35.
No, I follow your submission that they don't need to use Regulation 35. Sorry, maybe I should stop, but I was really asking a more technical question. If they do decide to use Regulation 35, they must issue a notice requiring something to happen. That's what Regulation 35 says. And I was just slightly quizzical as to whether that's why that wouldn't fall within Section 83 and give rise to an appeal.
Well, the issue, I suppose, is that, as Mr. Ghosh pointed out, VAT is a self-assessed tax. So the taxpayer has put in the return. And if the commissioners exercise this power under Regulation 35, in the paradigm case, at least, where the taxpayer has made a disclosure saying there's an error, we want it to be corrected and the commissioner issue that direction, the taxpayer finds itself in the position where, if it gives effect to the requirement of the commissioners, it has assessed itself in compliance with the direction of the commissioners in the amount in question. So the essence of my submission on this is one of the principal reasons Regulation 35 is not necessary in order to achieve the outcome for which the commissioners contend is that it would be, put it this term, a useless formality if the commissioners made that requirement, because the taxpayer is plainly not going to correct its returns. Its dispute is with the commissioners regarding the decision not to give the credit. But to get all that said, on the specific issue which my lord raises with me, if the commissioners had exercised a power to issue a requirement under Regulation 35 that had effect of denying the VAT credit, then one can certainly see the proposition that, well, that would fall within one of the statutory grounds of appeal under Section 83.
Yes,
However, the essential point that we have sought to make in our case is that Regulation 35 as such, a direction under that, is the exercise of a discretionary power. That discretionary power to make the requirement appears to be amenable to review rather than appeal.
Right. Okay, thank you.
Lords, that was all I wanted to say about Regulation 35, and indeed those are my submissions on behalf of the Commissioners, and for the reasons which I've given, I invite the Court to refuse the taxpayers' appeals.
Thank you, Mr. Thompson.
I'm obliged.
Mr. Ghosh.
I'm very grateful. All I want to say about the issue to do with Section 73 and the output and input is this. I think my Lord Hodge and I were at cross purposes. My case is simply this, that the right to assess under Section 73(1) is when the commissioners have an opinion that the return is incomplete or incorrect. And my point was this, that they knew in January 2004 that so far as HMRC were concerned, the return was incorrect because they were using the wrong method. And then in response to the questions put to me by Lord Hodge, well, it was a group VAT return, how were they supposed to know? In other words, that 36, what was the multiple? What were they supposed to apply it to? My response was, there could have been something, even if it was the global VAT return, they could have then reduced that under Section 73(9). They had absolutely an opinion that triggered Section 73(1). That's why it was responsible for the upper tribunal to make the decision it did. And I, in my respectful submission, am being responsible in advancing this before this court. HMRC knew that the return was wrong, and there was a number somewhere, a prima facie number, not the platonic number, that they could have exercised best judgment, because that's what I was saying. The revenue aren't saying they couldn't have issued something. And then they could have reduced it under 73(9 or refined it. I'm saying no more about that because the court's come to a view on this issue number 1, but to be fair to those behind me, and to be fair to my submissions, that's what I was saying, that the actual knowledge that the return was being made, or the multiple returns were being made on an incorrect basis, that was actual knowledge so far as HMRC were concerned on the 29th of January 04. And it's no part of the revenue's case that they couldn't have made a best judgment then. That's all I was saying. And that's a fair submission, but I'm not going to keep saying it because that's not what you want to hear from me on reply about. But the reason that this is so important is that, this I do want to air, the legal question about if I discover I'm HMRC something new about your VAT return, does that let me touch everything else in your computation because VAT is a net liability? And that's a critical question. And in my respectful submission, if you'd taken a different view of this issue than the one that your lordships have, that's a critical issue that has profound implications for all types of tax return. My Lord Reid, my Lord Sales will recollect a year ago in Tooth that was aired very, very lightly and then it disappeared without trace. That's all I want to say about that other issue. And that's why I fear I was at cross purposes with my Lord Hodge. It's not to do with the VAT account. Now, and anyway, your lordships have my submission on that. It's an important point. That ship has sailed. Coming on then to the issue about implication. Please may I make this very important preliminary point about, and the way I put it to my Lord Hamblin was that there are squads of cases saying, of course, national laws which withhold repayment of input tax are 6th Directive compliant and now Principal VAT Directive compliant. Mollen Hyde's one of those. That's not the issue before this court. This court is asked to answer the question, do we have this in domestic law in the first place? Because I said in open court that had the UK VAT Code had such a provision, so long as it was proportionate, we wouldn't be complaining. We couldn't complain. And for the court's note, it's paragraphs 5 to 11 in Mollen Hyde at page 2458. That page, I'm assured, is right. That makes it clear that what the court was looking at was domestic Belgian legislation and saying, yes, you can have this. That's not the exercise this court is being asked to undertake, to address. The court has my submissions that if you look at, and I can hardly bear to say it, but paragraph 4 of Schedule 11, that paragraph forces me to accept that there's no immediate duty to repay. It qualifies Section 25(3) because the commissioners are entitled to ask for evidence such as they may require. That's the verification exercise that my Lord Sales was interrogating this morning. We've always accepted that. What we complain about are these communications which, had they been assessments, would all have been out of time. Had they been Regulation 35 directions, they would all have been out of time. And just about that, this actually helps to make my complaint about these communications good. If, please, the court has the proper FTT decision, the revised one, and please look at paragraph 207. The court will see that the first-tier tribunal thinks that that's what these communications are, Regulation 35. Do you see that sentence, please, at the end?
I'm so sorry. Can you give us the page? Oh, it's in the separate
It's for once I can't, but...
No, all right, fair enough.
It's paragraph 207, and it's the last sentence.
It's page 30 of 48.
It starts at 29, that's right, and goes on over the page to 30. They quote Benridge. And they say, look, there's no general power to amend, it's a Regulation 35 or nothing. What they can do and did here was to issue decisions indicating what amendments would be acceptable. Now, they're not Regulation 35 amendments, they're not assessments. And what does that tell us? They called themselves protective assessments, which did not ask for the extra evidence for paragraph 4 of Schedule 11. And they were misleading. The explanation of what these communications are, what these letters are, were freely acknowledged in open court in the tribunal to be misleading, not what they said they weren't what they said they were. So the proposition that this court is being asked to endorse is that something which would have been an out-of-time assessment, something that would have been an out-of-time Regulation 35 amendment, is nevertheless in time to permit a withholding of a repayment of excess input tax. Sourced in a power that's implied in either care and management, not that. That's narrow. Or Section 25. And that is an exercise of statutory construction. Now, what's very, very interesting and informative and important is that Chamberlain, which my learned friend Mr. Thompson mentioned to you, paragraph 26, tells you that for a payment trader, so it's where the output tax exceeds the input tax, that counts. Because VAT is a self-assessment tax, it makes good everything I've been saying, that the assessment is good at the time the return is made, because that's when the debt is created to the Crown. The quarrel between two sides of the bar in this case is that they say it doesn't just make a difference, it makes all the difference that you're a repayment trader, that you're £1 in excess either way. Because then what's said is, there's no right to this repayment. It's not like your output tax, which creates a debt the nanosecond you put your return in. It's not like that at all. You have to wait, by implication. Now, can I please address the court in Trade Corps? And it's paragraphs 17 to 19. I think on page 2252 to 2255.
Page?
Please just give me one moment.
I think it was 2253 from my notes.
17 starts at 2252, just at the bottom, my lord. Now, if I could take the court through these paragraphs. Paragraph 17 and 18, you've looked at them before, but what Mr. Justice Lightman says, this case was all to do with interest. He says, you put in a VAT return claiming a repayment of input tax. HMRC thought you were crooked because it looked like an MTEC fraud. It wasn't. You were due that money. Trade Corps said, well, we want interest. You took a very long time to give us our money back. Held, no, you don't have a right to anything until it's adjudicated, established. Now, and that's the point that interest starts running, and it's an interest which is actually at the discretion of the tribunal. That's the relevant provision that you'll see at paragraph 19. And the reason for that, says Mr. Justice Lightman, and this reasoning is dead against me. I'm submitting it's just wrong. He says, and I say this very, very respectfully about the analysis in 17 and 18. He says there can't be a right to repayment of this input tax, because what you've got, and there are two separate ideas going on here. One is it's a running account. Sometimes you owe the government money, sometimes they owe you money. And there can't be a right to interest until you've got a kind of defined point. That as an explanation of VAT is simply wrong. VAT is a tax that is assessed on a period-by-period basis, usually quarterly. The other idea he uses, the learned judge, is one of set-off. That's equally, in my respectful submission, wrong. To an English lawyer, I do mean English, to an English lawyer, set-off might mean something like English equitable set-off. And that operates independently of pleadings. To a Scots lawyer, it's compensation to liquid debts. But Scots law is different to English law here because you can't set off against a future or contingent debt. In English law you can. I know you can because I won a case called Mellom and Burton in the House of Lords that says you can. Now, that idea is equally, in my respectful submission, misconceived when you're talking about VAT. It's not to do with set-off. So, what Trade Court establishes is because of what, in my very respectful submission, is a misconceived analysis of either a running account or set-off in private law, either in England or in Scotland. There is no right to interest until the claim is adjudicated, established words of that nature. And that flies in the face of VAT being a self-assessed tax. Now, it's in that light that I said to the court, the Revenue has got a list of protective measures, and Parliament can introduce a further one, that they don't have to pay the input tax until they're satisfied. But this list is pay subject to conditions. That's if the trader hasn't made previous supplies. Pay with asking for security. Pay and then assess. Not pay until supporting evidence. My lord, I'm sorry.
I missed this penultimate one.
Well, I'll just list them again. Pay subject to conditions, but that's specific and restricted. Pay and then assess. Don't pay until you've got the evidence. That's my paragraph 4 point that I've done to death. Pay and ask for security. That's paragraph 4 again. Or ask the trader to amend the VAT return. That's regulation 35. They've got those powers. And what's very telling is that in section 73.2, this is if they pay and then assess. Section 73.2 specifies an assessment for an amount that's been credited or repaid, which ought not to have been so paid. So the presupposition of the draftsperson is that there's been a payment made. The very assumption in 73.2 is of a payment that shouldn't have been made. And that's why I say it meshes with section 25.3. Because, and I don't at all want to be uppity. When I objected to the painting of the taxpayers' submissions as being, well, what are you saying? They have to pay this credit straight away. That's ridiculous. They have, or you'll threaten them with information gathering powers or investigations. I'm saying, well, no, I'm not saying that. I'm saying section 25.3 imposes a duty. That duty is cut down in specified circumstances in the rest of the section. You've seen them, including not paying if somebody hasn't delivered VAT returns. And you can absolutely assess straight away. And if you do that, if they appeal against that assessment, they have to pay that tax into the tribunal, subject to hardship. And that's why I say it would be wrong of this court to imply a power to refuse to decide to refuse to repay the input tax out of time as to when an assessment might have been. 73.2 says you shouldn't have paid it, assess and get it back. These were too late. Out of time for a regulation 35. You've got the picture. as a matter of implication, as a matter of statutory construction, that's the exercise this court's been, and this is very important, and it's important also for this reason. I think I mentioned this this morning that these communications were made on the basis of reducing the repayment of input tax because of under-declarations of output tax. If the court might remember me saying that, and I gave you the paragraph references. The scope of an implied power to deal with under-declared output tax out of time why would it stop if the revenue's right at simply not repaying excess input tax? And that's why I'm delivering to the court something actually quite profound, that this is a back door to allowing HMRC to do what it wants with these inhibits, not respecting the time limits. And this implied power would be there even if the revenue had all the evidence they could and should have assessed under Section 73. And in those circumstances, from a learned friend, Mr. Thompson, to say, well, you can withhold tax if somebody's not made VAT returns, it's even more obvious you should be able to withhold the repayment of the tax if somebody has made the correct returns, or the returns they're obliged to make. That doesn't follow at all. So both the issues before this court, but the one I'm addressing the court on now, are massive issues for the scope and content of the revenue's compliance powers. And there's a read across because the revenues relied on care and management powers, they're also in the TMA. The court knows that. This is not, and complexion here matters. And it's been not that far below the surface with some of the questions put to me about how disorganized DCM were about their VAT affairs and the input tax. And they were, I'm not defending that. But they get the protection of limitation like everybody else. There's no dishonesty pleaded here. As a separate, and there's a long stop period of 3 years in Section 77. Then DCM deserves the protection of this court.
It's 4 years, isn't it?
It was 3 and then it changed to 4.
Right.
Just to be clear, so in the relevant period, we're talking 3.
I think it's
right?
3.
It was 3 years when at that period.
Yes. So it's when these questions become clear on both issues, but this one is the one I get to speak about.
And so, I'm so sorry, just on the facts, the relevant letters were sent with, and indeed the 20th October 05 assessment were made within that 3-year period, were they?
On the issue that I've lost, that was in time.
In time,
if,
right, okay.
if what you're allowed to do is to touch the output tax adjustment because
Yes,
you've
okay.
discovered something new, that's why this issue was so massive.
Right. And in relation to the issue which you're now addressing us on, Were assessments eventually made by the revenue?
No.
So they just never made an assessment?
No, never. The last thing we got was what is the substance of Appeal 6, which is this letter of 2013 that says everything we've done on the previous letters we're confirming, and here's some decisions on some more VAT periods. That's what's invidious. To step outside the mechanism of assessments, of Regulation 35 adjustments, of the other protections you've got under Section 25, of Schedule 11, that's what's invidious. And
but just to, sorry, I'm just trying to see what you could do to protect yourself. So I think it's being said you could now even bring judicial review proceedings. Is that right? To make the revenue make some relevant decision. And I think you told me this morning that in any event you would have a right of appeal against the provisional assessment letters that you showed us under Section 83.
The position's this: we think we could appeal against these letters because they're decisions made to do with input tax or output tax. The Revenue's position is we shouldn't. We can only JR them, in which case we're miles out of time. And the cross-checks which were coming from your lordships, really across the bench, look, is this really a problem? Do they get interest? No. We don't get interest until the claim is established. It's not like a payment trader. We can appeal, but what do we appeal against? An out-of-time decision. That's what's unfair. That's what's invidious. So my Lord Sales, in asking me, do we think we've got a right of appeal against these decisions? Yes, very firmly, we're here, and we're exercising it. But we shouldn't be here. Because if that had been an assessment, it's too late. The whole point about a limitation period is that there are things wrong in any area of law, tax in particular. I lost a case in the Court of Appeal called Leeds City Council, which haunts me still, where there were many millions of pounds that Leeds City Council had overpaid, held, and it was accepted. They shouldn't have paid it. Held against me. That's life. That's what a limitation period does. So my response to my Lord Sales, is there a right of appeal? Contrary to what the Revenue say, yes. Why do they get to assess and make me appeal out of time?
I'm sorry to take up time on this, but under which part of Section 83 do you say you have the right of appeal?
I think it's C. Let me find it.
So just straightforwardly 1C, the amount of any input tax.
Yes.
Which may be credited.
Alternatively, B, the VAT chargeable on the supply of any goods or services.
Alternatively, if they used it to up the output tax to a point where I owed them money. Or it could be both, because as I say, it's this is a very protean type of decision, where the claim for a repayment of input tax could be reduced either because they're upping my output tax or reducing my input tax claim.
But under Regulation 35, could you not appeal an instruction if they instructed you to change the VAT chargeable on supply of goods or services? Could you not appeal that?
In my respectful submission, I think the answer is yes. The only authority which is remotely in that territory is capital accommodation that says no, but that's a different case because that's where somebody was trying to force the Revenue to make a Regulation 35. But the point I'm making to my Lord Stephen is, why am I being made to appeal something that's made out of time? That's what's unfair. Yes, it's even worse if I can't appeal it, which is what the Revenue say. So, My ambition is that the court at least takes the burden of my submission, that in my submission, the revenue is quite wrong to say I can't appeal these letters. It's the very fact I'm having to appeal that is wrong. They're out of time if their assessments, they're out of time if the Regulation 35 adjustments, and they don't reflect any of the other powers, which takes me back to, well, can it be some sort of disguised request for evidence? No, it's not. That's not what it says. And the reason that this court should not have any discomfiture, as I've said over and over and over again, the revenue's protected. If they want to be even better protected with the right to withhold, not just as against a trader who's never submitted VAT returns, but against all traders, they can ask Parliament, and if she gives them that power, they can use it. But it is not there, in my respectful submission. It can't be there as a matter of implication. It's the opposite. Those provisions militate against it. And just in case the court revisits the Court of Justice cases, they're all, Mollenheid for instance, they're all to do with asking when the domestic law does give the fisc the right to withhold, that's compliant, that's okay.
Yes, you say the CJAU cases are irrelevant because you say the search here is for a domestic power, and you say there is none. But if there were, you would accept that it would be it would be EU law compliant.
Absolutely right, my lord. I completely. And put another way, the revenue, this is an obvious point, can't rely on the direct effect of the directive to give them powers they don't have.
They don't claim such, yes.
No. But that's what it would come to. Now, just before I close, because I'm pretty much there in my reply, I wanted to make the point I made on the issue which we've lost, because I wanted to make it clear that to make those submissions responsibly, I was relying on actual knowledge on the part of HMRC. And I was relying on the absence of HMRC saying they couldn't make any best judgment assessment without that. Why was that important? For the massive, massive, massive point, which the court will have to do. I don't know what the court will do with it. If I find something new, can I touch everything else in that computation, even though if that's all there was, I'd be out of time? Here, I urge the court that to observe that there comes a time when the Revenue and Parliament need to take responsibility to say we're covered, and we're actually covered 100%. It's not a question of tax leakage or fiscal or offence against fiscal neutrality here. But if they want to make their lives even easier, I haven't got that. Please may the court give me 1 moment. That is my reply.
Thank you. Now, I think Lord Sales wishes to seek a matter of clarification with Mr. Thompson.
Yes, if I may, Mr. Thompson. Sorry, just on this Section 83 point, in relation to the letters that went, stating provisional assessment, Mr. Ghosh says there is a right of appeal in relation to those under Section 83.
Yes.
but says that you don't accept that. Is that right?
No, and I'm not sure where that impression has come from.
So you would accept that there is a right of appeal
Absolutely,
in relation to those?
And it has been exercised in these proceedings.
And is that because it falls within either of subparagraphs B or C within section 83(1?
Correct. What we had said in our case, Lord, was as a reason against the suggestion that Regulation 35 has to be invoked was the proposition that there wouldn't be an appeal against a Regulation 35 direction. But no one is suggesting that this was a Regulation 35 direction. So far as the decisions in question are concerned, absolutely accepted that they were properly subject to appeal.
Yes, thank you.
Any matter arising from that, Mr. Ghosh?
Only this. You've seen that the FTT did think this was a Regulation 35 adjustment. There was discussion below as to whether a Regulation 35 adjustment could ever be appealed against, and it was not clear to me until just now that the Revenue accepted that we've got a right of appeal. But that's not what this case is about. This case is about whether you can make an out-of-time decision or not. That's all I want to say, Lord.
Okay. Well, we're grateful to all who've been involved in the preparation of the submissions that we've heard. We're grateful to Council, and we'll let you have our decision in due course. The Court will adjourn.